You're watching Bloomberg Law. I'm Pacchia. Last week, the House and Senate came to an agreement on a new piece of legislation that aims to create jobs by making life easier for startup companies that wish to go public. The Jumpstart Our Business Startups Act, or JOBS Act as it's known, is expected to be signed by President Obama today. But critics of the bill are wondering if it puts investors in harm's way. Joining me now to discuss is Anna Pinedo. She's a partner at law firm Morrison Foerster based here in New York. Welcome. Thanks so much for coming in.
Thanks, Lee.
So before we get started, a lot of people have been asking me basically all week about whether there's even a need for a bill like this to be put out there. What problem is it purporting to address?
Well, essentially, the bill is supposed to make access to capital easier for emerging growth companies. In reality, it actually facilitates capital formation for emerging companies as well as pretty well established companies. Mm-hmm. In terms of need, I think that there is a very urgent need for a measure like this. Over the last few years, we've seen the regulatory environment become more constraining for emerging companies as well as for companies that are already public. Mm-hmm. And the last time that there was any real revamp of our securities laws was back in 2005 when we had securities offering reform.
It just strikes me as such an unusual statement to say that companies like Facebook's and the LinkedIn's of the world at some point along the way have trouble accessing capital. I mean, everyone wants to invest in a Twitter or Facebook at an early stage. We have a show here at Bloomberg devoted entirely to emerging companies in the tech space. I think it comes as a surprise to a lot of people that tech companies can't access capital to the extent that they need to at certain stages in their development.
Well, I think it's important to remember that it's not just the Facebooks of the world. There are a lot of other very strong companies that do find it difficult to raise funds and to do that in a way that's efficient for them. What we've seen over the last few years, and this is pretty much incontrovertible, is that the number of companies in the United States that decide to pursue IPOs has gone down pretty steadily. And if you take a very close look at the numbers, what you'll see is even more striking, and that's that smaller companies tend to shy away from IPOs more than they did in the past. So in the last probably 5 or 10 years in the United States, we've had a noticeable decline in the number of smaller companies that are deciding to pursue IPOs. And I think the connection to jobs is a very close one and an important one to keep in mind. And that is that it's really in those years after a company goes public that it's able to create the most job opportunities.
That's an interesting point. Yeah, I was talking to someone earlier today about the maker of Angry Birds, the game on the iPad is going to go public somewhere other than the United States.
And I think we've seen that in a few instances with interesting and good companies going public in Hong Kong, going public in London, and choosing to avoid the United States.
This bill has come under a lot of criticism, particularly in the last couple days. Opponents are saying that this bill simply goes too far in loosening disclosure rules and weakens investor protections. To what extent is that true?
Well, I think you have to parse through the bill. And I would say that those criticisms perhaps are more accurate as to, or those concerns are more valid as to certain parts of the bill and not necessarily as to others. For example, Title I of the legislation addresses emerging growth companies. And all that really does is create this new category of issuer, an emerging growth company, a company that has total revenues of less than $1 billion, and makes available to those types of companies a phased-in or scaled disclosure system. So we're not talking about wholesale changes to the disclosures that investors would receive. And it's not even a regime that's all that different from the one that we used to have years ago, where smaller businesses could use Form SB registration statements that required that they provide data for a shorter period of time or less detailed data in certain respects. So from that vantage point, I would hardly say that an investor could feel like they're being cheated or that there'll be less transparency. I do understand some of the concerns that have been raised in respect of crowdfunding and maybe some other pieces of the legislation. But realistically, from a capital markets perspective, I think the part of the legislation that's going to have the greatest impact is the creation of the emerging growth companies and this whole notion of the IPO on-ramp, which is very appealing.
According to Bloomberg News, one measure would restore communications between banks, research departments, and underwriting departments. That would effectively roll back regulations that were put in place back when Eliot Spitzer was Attorney General for the state of New York that came after the tech bubble burst 10 years ago. These rules were aimed at preventing Wall Street firms from puffing up their coverage over small firms that other departments in the bank might be doing business with. Essentially, some people are saying that this would reinstate conflicts of interest on Wall Street. To what extent is that true?
Yeah, I think that it would be helpful if people sort of read more closely. I don't think that's an accurate characterization of what the legislation does at all. Indeed, after Sarbanes-Oxley, there were quite a number of rules that were put into place by the SEC and also by FINRA. 2711, which was put into place by FINRA, intends to address conflicts of interest and to prohibit certain problematic behavior by research analysts. Now, what this legislation does isn't to sort of gut that, as many reports have claimed, but rather solely in the context of encouraging investment banks to promote research for emerging growth companies. It does permit research analysts to engage in certain discussions with investment banks. Now, it continues to require that investment banks provide disclosures about conflicts of interest, so they would have to provide disclosures in their research reports. They would also continue to have to follow all of the compliance procedures that have been set up in terms of not having research pay decided by investment banking revenues and other things that we saw as perhaps being cause for concern during the tech bubble. So in effect, all it really does is facilitate communication. And if you talk to most people on Wall Street, they would tell you that a lot of what came after the research analyst settlement didn't make a whole lot of practical sense and created a lot of burdens and really changed the economic model for research in the United States and ultimately led to a pretty chilling effect on research for mid-cap companies.
Mary Shapiro is not thrilled with this particular provision. Does this rollback make life more difficult for the SEC?
I'm not sure that I see how it does that. In terms of the firms that were settling firms, it's still probably necessary for those settling firms to actually go back and have the benefit of an amended order. And the order has been amended in recent times to permit communications that are a little bit freer. So it wouldn't be the first time that the order's been amended. I'm not sure that it would in any way sort of create issues for the SEC from an enforcement perspective or otherwise.
Let's talk about the crowdfunding provision. Why was it so controversial, and how will it change things going forward?
Well, I think that crowdfunding has garnered certainly a lot of interest, and it sort of captures everyone's imagination in the sense that it's this very democratic, almost populist notion that anyone can participate in a fundraising venture for a company or an idea or a project that they believe in and that they want to support. The earlier House version perhaps lacked a number of investor protection provisions that could have been useful. And I think what we see in the final legislation, which incorporates the Senate version of the crowdfunding proposal, certainly has many more investor protections built in. So in order for an issuer to avail itself of the crowdfunding exemption, it really has to use a funding portal or a broker-dealer. And effectively, that broker-dealer or funding portal is going to act as a gatekeeper.
What does this, the passage of this bill say about the direction of things in terms of financial regulatory reform? It's essentially a deregulating bill in an environment where many people are clamoring for more regulation, given everything that's happened in the last 3 years. Does this put us on a deregulatory plane?
Well, first of all, I would quibble with characterizing it as a deregulatory bill. I think we have a very well-structured series of securities regulations, and the process for securities offerings is heavily regulated, and we're not moving away from that by any means. I think that, again, Title I, which is most significant relating to emerging companies, or even loosening the prohibition on general solicitation and private placements, really shouldn't be characterized as deregulatory. I also think it's not necessarily appropriate to sort of link it or make it some statement on financial regulatory reform and Dodd-Frank, because I think that there are two very separate notions that motivate both regulatory reform as it's embodied in Dodd-Frank and encouraging entrepreneurship and innovation in the country, which I think is very well reflected in this bill. So I don't think it's any kind of referendum on regulation or the direction that we'll be headed in the next year or years to come.
That's Anna Pinedo, partner at the law firm Morrison Foerster. If you'd like to learn more about the cases and issues we just discussed, be sure to check out our offerings on BloombergLaw.com and also on the Bloomberg Terminal. You can follow our updates on Twitter and see more of our videos on YouTube. I'm Pacchia. Thanks for watching.